Hello, everyone, and welcome. I'm glad you're joining me for this conversation about estate planning for young people. My name is Amber Flieger. I'm an estate planning attorney here in SeaTac, Washington, and I work at the Rehberg Law Group. I'm excited to talk about a very relevant topic to many, and that is estate planning for and about young people. When many of us hear the words estate planning, we picture retirement, significant wealth, or decisions that belong much later in life. But the need for a plan is not really about age or the size of an estate. It is about having the right people authorized to help, making your wishes easier to understand, and reducing uncertainty when life changes unexpectedly. Today, we'll look at 3 common stages of young adulthood: turning 18, getting married, and becoming a parent. We'll also talk about life events that should prompt a review, what may happen when the documents are not in place, and how families can begin these conversations without making them feel frightening or overwhelming. This presentation provides general educational information, not legal advice for any one person or family. Estate plan choices depend on individual circumstances and are very customized, and current laws and state laws differ. So, a qualified attorney should help evaluate a specific situation. With that in mind, let's begin with the question families ask most often. What documents does a young adult actually need? The honest answer? It depends. I know, how lawyer of me, but it's not what you think. 2 people of the same age can have very different needs. One may be living at home and attending school. Another may own a business, share a home with a partner, have a child, or manage a medical condition. Their documents should reflect those differences. A useful estate plan usually answers a few practical questions. Who can make healthcare decisions if I cannot communicate? Who can handle financial and legal matters if I am unavailable or incapacitated? Who should receive my property? Are there people or relationships that the default legal rules may not protect in the way that I intend? And who needs access to important information in an emergency? As we move through the presentation, treat each document named on the slide as a conversation prompt rather than a one-size-fits-all. The goal is not to collect paperwork or expenses for its own sake. The goal is to create a coordinated plan that fits a person's life now and can be updated as that life changes. A simple way to organize the discussion is to look at the 3 major stages of young adulthood. The 3 major stages. We'll be looking at recently turning 18, recently getting married, and becoming a parent. These stages are useful because each one changes responsibilities and relationships. At 18, parents may discover that they no longer automatically have the authority they once had to receive information or act for their child. I see this come up often when kids go off to college and they need mom or dad to call and help get a prescription moved over. Well, if they are above the age of 18, mom and dad is going to need permission. Next, we see marriage. Marriage can change property, beneficiary, insurance, and decision-making considerations. Parenthood introduces questions about guardianship, financial support, and the care of a child if something happens to one or both parents. Each of these will be discussed in more detail in the upcoming slides. So let's focus on the first one, recently turning 18. Turning 18 is a milestone, and it's also a change in legal dependence. A parent who has always scheduled appointments, spoken with providers, or helped manage practical matters may no longer be able to step in automatically. That can be surprising to both the young adult and the parent. This is why powers of attorney are often among the first documents to discuss. A healthcare power of attorney can identify the person authorized to make medical decisions if the young adult cannot. A financial power of attorney can authorize a trusted person to handle defined financial or legal matters. The right scope and timing should be discussed carefully because these documents grant meaningful authority. A directive to physician, also sometimes known as a living will, records wishes about certain medical care, while a HIPAA authorization can allow specific people to receive protected information. Together, these documents can make it easier for the right people to communicate and act during an emergency. A clear example is your power of attorney for healthcare and your HIPAA. You would like those who can make you would like those that can make healthcare decisions to be informed about your healthcare status. And the HIPAA gives them that. And that's why it's important to have both documents. A living trust or will may also be appropriate depending on assets, family circumstances, privacy goals, and other needs. Beneficiary designations on retirement accounts, life insurance, or similar assets should be reviewed because those designations can be an important part of the overall plan. The main takeaway at age 18 is simply adulthood creates independence, but independence works best when there is a deliberate backup plan. The young adult should remain at the center of the conversation. They or those around them should help them choose trusted people and understand the authority that each document gives. Next, we'll be taking a look at marriage. It is another natural point to pause and review a plan. A wedding does not automatically answer every question about decision-making, ownership, beneficiaries, or inheritance. It's important to look at the couple's actual circumstances. What each person owns, what they may acquire together, whether either person has obligations from a prior relationship, and what they want to happen if one spouse becomes incapacitated or dies. For example, I recently got married. Prior to that, it was designated by state law that my things would go to my family, my mom, my sisters, my brothers, not to my current spouse, as I was not married to him at that point. However, little did state law know I had been with him for over 10 years. So even in my eyes, I would feel, oh, he is entitled to some of my assets if I were to pass away. But up until we got married, state law did not believe that either. So, now that we are married, it is automatic that it would go to him if he were to be here. However, my beneficiary designations, if I haven't listed him as it, now would be the time for me to think about that. Other things to think about is if a couple did not complete a prenuptial agreement before marriage, they want to discuss a postnuptial agreement afterwards. How to handle the assets if we were to separate. What would that look like? Some other things to consider are powers of attorney. Should identify who can act. The will can coordinate the couple's wishes for property and beneficiaries. Depending on the situation, a community property agreement may also be a part of that discussion. So now that I am married, my husband and I, we can both have wills, but also have a community property agreement, which would allow for us to avoid probate at the first passing. Whereas before this point, even if I had appointed him personal representative and I wanted him to manage things, he would have to go through probate because he did not have that opportunity to have a community property agreement because we were not married. Again, this is also the time to review the beneficiary designations, the directive to physician, HIPAA authorization, because marriage does not eliminate the value of written instruction and clear access to information. Additionally, marriage involves a name change, potentially, a new employer, or a new insurance policy can leave out accounts with outdated or inconsistent instructions. My will says one thing about IRAs, but I beneficiary designated it to someone I no longer speak to. Well, unfortunately, it would have to go by the beneficiary designation, even if I thought it was going to say my husband. Finally, it's important to consider life insurance and other forms of protection. The question is not simply, do we have a policy? It's, okay, would the surviving spouse be able to manage housing, debt, income needs, other obligations? An estate planning attorney, financial planner, insurance professional, and certified public accountant can help coordinate these pieces. And finally, we're going to be taking a look at parenthood. And as many of you know, parenthood comes at very different stages in life. I have some friends who have been married and have 3 kids. I have others who could not fathom being married at this point. So parenthood raises the stakes because the plan now needs to protect the child as well as the adults. Whether you're in your early 20s or you're in your 40s, this is something that does need to be accounted for and reevaluated. This starts with powers of attorney. Parents should identify trusted people for health care and financial decisions, and they should discuss any provisions connecting to the care of their child. The documents must be coordinated carefully so that emergency authority, long-term guardianship wishes, and financial responsibilities are not confused with one another and cause conflict amongst the parties. A will or living trust can record proposed guardianship provisions and explain how assets should be managed for a child. If a child has special needs or may need benefit-sensitive planning, specialized provisions may be essential. This is an area where individualized legal advice is especially important because an ordinary distribution can create consequences the family did not intend. So, for example, if you are receiving government benefits and receive a large chunk of money outright, then they may say, hey, you actually do have funds and you are no longer eligible for these benefits. It's important to always think about the branches of your decisions. If the parents are married, a community property agreement, as I previously said, may be considered. Beneficiary designation should always be reviewed after the birth or adoption of a child. Parents should not assume that adding a child's name directly to an account is always the best way to provide support. Additionally, parents should not assume that a stepchild is considered a child under state law. It is super important for the parent to identify the appropriate structure depending on the child's age, needs, and type of asset. Additionally, healthcare documents, including a directive to physician, HIPAA, remain part of a parent's plan as always. And as I will keep reiterating, life insurance and other protections should be evaluated. Think of child care now, housing, education for the child, debt. What happens if one of the parents loses their job? What if they both lose their job? Do we have to think about unpaid caregiving? These are all super important factors. Family may also want to explore educational savings accounts and educational trusts and 529 plans. Things to focus on the child's future, not just their own. Those are the 3 major life events, but other life events to consider are a good plan should be reviewed when life changes enough that old assumptions may no longer fit. So if you review and you're like, wow, we don't talk to them. She is now, she's no longer a minor. She is 35. These no longer fit your plan. A significant increase or decrease in income can affect insurance needs tax planning, savings, and the amount or type of property the plan must address. A new occupation may bring different risks. If you are in an occupation that gets sued a lot, or receiving different benefits or retirement accounts now, even a routine job can leave beneficiary designations behind at a former employer. So even if you are working at McDonald's or Starbucks, or if you're working at a law firm or financial planner, or you're an influencer, depending on what type of account you have, it is very, very important to have beneficiary designations, but then also make sure they stay with you. If you start at one job and then you left to become a social media or a tax advisor, and you're no longer in the insurance game, make sure you bring your retirement plan with you, or the benefit plan that was provided there. We don't want to lose out on things that are yours simply because we forgot to review and look at it. Another good thing to talk about is moving to a new area. Laws and documents, practices can vary by jurisdiction. What is relevant here in Washington is not relevant, may not always be relevant in Oregon or in New York or California. So it's really important that if you were to move, or the person who was a convenient choice when you lived by, and now that you've moved cross country, say, may not be the most practical choice anymore. Unexpected accidents, injuries, or health concerns can change both urgency and priorities. Documents are signed while you have time and capacity to have thoughtful decisions is important. And finally, considering family relationships. Who communicates well with who? Who is dependable under pressure? And who is going to take that fight or flight and fly out of there? Are there any conflicts that could make a particular appointment difficult? We're not going to put the two siblings that argue constantly together and they have to make a unanimous decision. No decision's ever going to get made at that point. Choosing an agent is not an honorary role. It's a practical job that requires trust, judgment, and the ability to follow the person's wishes. These events are reminders to reopen the plan, ask whether it still fits, and update it when needed. Additionally, there are other life events that deserve the same kind of review. Changes in family dynamics, such as marriage, divorce, birth, death, adoption, all can alter who should serve, who should benefit, what support is needed, because the support needed with a marriage may be very different than the support needed for an adoption. Buying or selling a home, land, or another major asset can change ownership, debt, your liquidity, the way property may pass, as well as your earnings or liabilities. A long-term relationship deserves special attention. If partners are not married, they should not assume that the law will always treat them the way that they would choose. As I said previously, before we got married, he would not have just received everything that I had wanted him to, without me specifying it. Now that we are, there is that state law, which is great. But now we can take the next step to even reduce expenses and court costs and time that just may not be necessary. All because we had that conversation with not just each other, but with our attorneys, financial planners, CPAs. Lawsuits or significant liability concerns may affect how a person thinks about risk, ownership, and asset protection. Starting a business, ending one, or buying an ownership interest can add agreements, valuation questions, succession planning, and obligations to partners or employers. Remember, no single event automatically requires the same solution for everyone. The practical habit is to schedule a review whenever a major relationship, asset, responsibility, or risk changes. A short check-in can reveal that the current plan still works or identify a gap before it becomes urgent. Now, what happens if these documents are not in place? And I would say that applies to probably 60% of the people out there. Honestly, maybe more. In many situations, default legal rules fill the gap. Those are called intestate laws. Those go based off the state laws. Those rules are necessary, but they're written for very broad categories of people. They do not know a particular family's relationship, preferences, or concerns. The Revised Code of Washington, the RCW referenced here, contains rules that may affect decision-making, property, probate, and other issues. Which rule applies depends on facts. That is why it is risky to rely on a general assumption, such as, my family will know what I want, or my partner will automatically be protected. That's not always the case. Without coordinated planning, an asset may become part of a probated estate when the person expected to pass another way. An outdated beneficiary designation may point to the wrong person. Family members may disagree about who should act. A young adult's life stage can make these gaps especially significant because relationships, property, and responsibilities are constantly changing. From the age of 18, from when you get married to parenthood, those are all significant changes. One thinks about a partner, one thinks about yourself, and one thinks about this child that is someone that you've brought into this world that you need to make sure is protected. This is not meant to create fear. It's really not. It's meant to show the value of clarity. Planning replaces avoidable assumptions with written choices. It gives trusted people for a better roadmap when they need one the most. It leads me into discussing those trusted people, not just for what you want in regards to documents and your agents, but also for your professionals. Putting together a team, the three-legged stool. On the slide includes an estate planning attorney, a certified financial planner, and a certified public accountant. And each professional sees a different part of the picture, but all are so essential. And please ignore the picture of the four-handed people. We are talking about three-legged stool. So we'll move on from that. Okay, guys? The attorney helps translate personal goals into appropriate legal documents and advises on how current law applies to the individual's situation. And then the financial planner, they're taking a completely different look at it. They're looking at cash flow, investments, retirement accounts, insurance needs, education goals, and long-term financial resilience. Let me tell you, your estate planning attorney is not looking at that in the same way your financial planner is. Then we have your CPA. Now, your CPA can help identify tax considerations and explain how business, income, or asset decisions may affect the broader plan. The point is not that every young person needs 3 complicated engagements on one day. The point is coordination. If one advisor changes the strategy or identifies a new issue, the other parts of the plan may need attention. For example, a new account or insurance policy may require a beneficiary update. A business decision may affect both tax planning and succession planning. Choosing professionals who are willing to communicate with one another with the client's permission is so important. Keep a current list of advisors and contact information for not only yourself, but also your agents. Because when you're not available and they need help, they're going to come to us. Most importantly, make sure the young adult understands the plan and remains the decision maker in every single one of these steps. The team provides expertise, but the plan is focused on the young adult, whether it's a young adult that's now a parent, now married, is single, but has acquired this business. All of these things are cause for different plans, discussions, options. And it's important to always have a team that is open to having those conversations with you. Now, say I'm not the young person. What should you do if you have a young person? Whether it's your sister or it's your grandniece. For parents, grandparents, or other family members, the first step is often a conversation. These conversations can feel difficult, touchy, and uncomfortable. It's because they touch on illness. If something were to happen to me, I'm not here. These conversations touch on money, relationship, and death. A young person may also hear concern as pressure or a loss of independence. The tone matters. Try beginning with a practical help rather than worst case scenario. No one wants to feel like they're being lectured, but you might say, now that you're a teen, there are situations where we may need your written permission to help. So would you be willing to learn what we need to get those documents or to do that? Or when we updated our own plan, we realized we never explained where things are. Can we talk about how you would want to handle an emergency? Ask questions before answering or offering answers. Who does the young adult trust? What matters to them about privacy and independence? Are there relationships or responsibilities the family may not fully understand? Listen, without rushing to correct or persuade. It may take more than one conversation. Honestly, it's going to. And that's okay. The goal is not to complete every document at the kitchen table. The goal is to make planning normal, respectful, and manageable. A calm conversation today can make it easier for the young adult to seek professional advice and make informed decisions tomorrow. Another great way to approach this conversation is to have these conversations at certain life checkpoints. As a young adult approaches each stage, focus on 3 parts of the conversation. First, explain the practical risks without turning the conversation into a scare tactic. At 18, the issue may be access to medical information or ability to help with finances. Before marriage, it may be ownership, beneficiaries, and mutual expectations. With parenthood, it may be guardianship, insurance, and structure for child's care. Second, explain what you have done in your own plan. This can make the discussion concrete and reduce the sense that you are singling the young adult out. You can share that you named agents, organized documents, reviewed beneficiaries, or told family members where key information is kept. You do not need to disclose every financial detail to model good planning. Just be willing to have that open conversation. Third is discuss options for agents. The closest relative is not automatically the best choice for every role. One person may be excellent at healthcare decisions, while another is more organized with financial decisions. The young adult should consider the trust, availability, judgment, communication, and willingness to serve. Because again, this is not an honorary role. This is a job. Be careful not to appoint yourself in this conversation when you're having it with them. Offer to help the young adult understand the options and let them make the decision with appropriate professional guidance. Respect is what turns a difficult conversation into a useful one. And don't worry, we didn't forget about our on-demand babysitters. Oh, I'm just kidding. I mean grandparents. Grandparents who regularly care for grandchildren should also ask whether they have the authority and information they would need in an emergency. Being a trusted caregiver does not always mean a grandparent can automatically consent. obtain information, or make decisions when a parent is unavailable. The family should speak with a qualified attorney about the documents appropriate to their situation and make sure those documents are current. Preparation is both legal and practical. Know whom to call, keep current contact information for parents, medical providers, school, all those other essential personnel. Additionally, understand the allergies, medication, any special care instructions, where important documents are stored, or how they can be accessed. The powers of attorney and other authorized documents should name the appropriate people and match the family's actual caregiving arrangements. As circumstances change, such as a move, separation, new school, or change in health, the family should review the plan. And additionally, one practical way to support a young adult is to help remove the barrier of getting started. And one of the largest barriers is that financial one. For some families, a gift certificate for estate planning services can turn a vague intention into a scheduled conversation with an attorney. If you consider this kind of gift, present it as a support for the young person's independence, not as a way to control their choices or gain access to private information. The client's relationship belongs to the young adult receiving the services, not the one paying for the service. They should be able to ask questions openly, choose their agents, and make decisions based on their own circumstances. Whether the assistance is a gift certificate helping organize questions or simply encouraging to make an appointment, the most valuable gift is a clear and thoughtful plan and just being open and willing to have that conversation. So thank you so much for spending this time with me. Really, my overall message is that estate planning is not reserved just for later in life. Turning 18, getting married, becoming a parent, changing jobs, moving, acquiring property, or starting a business can all be reasons to create or review a plan. A useful next step is to identify the life stage that applies to you today. List the questions that arises, whether you're a grandparent watching over your grandchild, you are a business owner looking to acquire another business, you are in a high-risk job. All of these things are super important to think about and discuss. If you would like to discuss your circumstances with Rehberg Law Group, we have a location here in SeaTac and in Bellevue. Contact information is shown below, along with the firm's email, phone number, and website. So thank you so much for listening. Bye.